hindi sumunod sa kanilang pasabi na mag-file ng aking counter affidavit. Nakakalungkot po ito sapagkat ito totoo. Inaamin ko po sa inyo kung ICC lang, hindi po talaga ako susunod. Hindi ako magpapasakop sa ICC. Pero dahil ginagalang ko po ang ombudsman, dahil siya po ay aking kaibigan na itinuturing, dahil nagkaroon na po kami ng napakahabang kwentuhan sa aking opisina nung siya po ay kalihim ng hustisya, nag-file po kami. Ito po, hawak ko po ang original. Dahil sa akin po, importante ang original. Ito po ang original, nakalagay po dito. Nag-file ako. Nakalulungkot po na pati ang media ay nakikisama sa ganitong klaseng propaganda na ang isang senador ay hindi sumusunod sa batas. Isang senator judge. Ito po, maaari ko po kayong bigyan ng kopya, mga mahal kong kasama, para mapatunayan na hindi ko po kayo ilalagay sa kahihiyan. Ako po ay nag-submit ng aking counter affidavit. At ganun din po, humihiling din po ako sa aking mga kasama, lalong-lalo na po sa aking kaibigan, Ginoong Pangulo, na sa mga ganitong pagkakataon, hinihingi ko po na tulungan din po ninyo kami. Na maipaliwanag din po namin sa media na meron din po kaming mga pagkakataon na ipagtanggol din ang aming sarili at kami wag husgahang kagad na kami hindi sumusunod sa batas. Yun lamang po, Ginoong Pangulo at tagapangulong hukom. Maraming salamat.
Senators Erwin Tulfo, Senator Judge Alan Cayetano, thereafter Senator Judge Tito Soto are recognized. What is your pleasure, Senator Judge Erwin Tulfo?
Mr. Presiding Officer, Senate President, ladies and gentlemen, this impeachment court was established to try the Vice President of the Republic. Ang punto ko po rito, kasi napapansin ko po ilang araw na nagagamit po natin ang impeachment court, ang oras po ng impeachment court sa pagpapaliwanag. Naintindihan ko po ang posisyon ng aking kaibigan, si Senador Robin Padilla, yung kanya pong frustrations. Pero gusto ko lang po sana ipaalala sa ating presiding officer, sa ating pong Senate President, at matanong ano po ba ang ating ginagamit na rules ngayon? Pwede po ba yung mga problema po labas sa impeachment court na ito o labas sa kaso ng Vice President ay dadalhin natin dito? Di po ba ang korte na ito na itatag para po sana kay Vice President at kay Vice President lamang? Mga ebidensya, mga testimonya, mga pahayag patungkol lamang po sana sa impeachment ng Vice President. Kasi dito pong mga nagdaang araw, Mr. Presiding Officer, Senate President, mga kasama, napansin ko po na nagagamit ang oras po ng impeachment court sa pagtatanggol po ng mga nakaraang araw ng sarili ng ilan sa mga kasamahan natin sa mga akusasyon. This is not the right forum and the right venue and not the right time to explain your situation. Kung gusto po ninyong mag-eksplika ng inyong mga saloobin, problema, maaari naman po ninyong gawin yan sa labas po ng oras ng impeachment court. Maaari pong sa press conference, nandyan naman po ang Senate media. Anytime po, nandoon sila sa Senate briefing room, press briefing room. Maaari din po sa Facebook o sa YouTube magpaliwanag. Huwag po nating gamitin ang oras ng impeachment court sa pagpapaliwanag o sa pagtatanggol ng ating mga sarili simula pa po noong nakaraang linggo. Because the time we waste here to defend ourselves, defend what we believe or what have you, is an injustice to the Vice President. Yung oras po na ito dapat ilaan natin sa pakikinig sa depensa ng Vice Presidente, sa mga akusasyon laban sa Vice Presidente, hindi po pagdidepensa sa mga sarili natin kung tayo inaakusahan ng kung anong mga ahensya, kung tayo po ay may mga kaso, may mga investigasyon. This is not the right forum, Mr. Presiding Officer, Mr. President, Senate President. This is not the right place. This court was established, was created, the impeachment court, for the Vice President and Vice President only. This should be her time. This should be her forum, not our forum here na ilabas natin ang saloobin natin, mga sagot natin sa mga akusasyon, mga kaso laban sa atin. And this is not also the time, Mr. President, Mr. Presiding Officer, na hanapin yung mga kasama nating nawawala, nakakulong. Dapat po doon sa Senado natin, sa sesyon natin, and not here in this court, Mr. Presiding Officer, Mr. Senate President. Kaya pakiusap ko lamang po sana sa ating mahal na Presiding Officer and Senate President, let us follow the rules. May rules ho tayo. Kung hindi naman ho patungkol sa Vice President na sasabihin natin, hindi naman po patungkol sa depensa o prosekusyon ng Vice Presidente natin, then wag na ho natin payagan na magsalita pa po dito because nasasayang. Every minute, every hour that we waste away from the defense or from the prosecution of the case of the Vice President, it is injustice. It is called injustice to the Vice President, to her family, yung anguish, yung kanyang sama ng loob, yung oras na nakabinbin ang kaso na ito. Let us do this impeachment trial as quickly as possible. If we have to clear the Vice President, then let's clear her. If we have to prosecute, then prosecute her with the evidence kung meron. Not waste our time kung ano-ano sinasabi natin dito to protect ourselves, to defend ourselves. This is not the right forum, Mr. Presiding Officer.
Kindly wind up,
Mr.
Senator
Senate
Judge
President.
Erwin Tulfo.
This is not the right forum for us to defend ourselves. Bring it somewhere else. Bring it to the press. Bring it to the social media, but not here. Thank you, Mr. President.
The remarks of the gentleman are noted. Earlier, Senator Judge Alan asked to be recognized. Are you yielding in favor of Senator Judge Padilla? And thereafter, Senator Judge Soto, thereafter, Senator Judge
Thank you,
Padilla,
Mr.
before the
Presiding
chair
Officer.
makes a ruling on the matter. Yes, Senator Judge Alan Cayetano is recognized.
Thank you. I'm happy.
You may proceed, sir.
I'm happy I finally heard Senator Judge Erwin Tulfo is concerned about the justice or injustice to Vice President Sara. That's good news. Regarding the waste of time here, sabi ni Senator Joker Arroyo, it is useless to argue a legal point with a non-lawyer. When Senator Marcoleta brought that up here, nagkaroon ng commotion. Senator Miriam stood up here many times and said, kaya ka nga nagpo 4 years na law school at nagbabar. So let me give my own interpretation. The impeachment court is formed with lawyers and non-lawyers. And we interact, and it's for everyone, and we're equal. But if there's an engineer here or a doctor, and they talk about medical principles, I have to either study and argue on medical principles. Hindi ko pwedeng sabihin, hindi, ganito lang yan, logic lang yan, etc. Diba? So, ang legal principle natin today is simple, integrity ng court. So, allow me to mention that to the people and help educate my colleague here. The integrity of the court and the justices or judges is always relevant. So if the Supreme Court or COMELEC, Court of Tax Appeals, Sandigan Bayan is being heard and the judges are being threatened, you give them time. So we cannot take the impeachment out of context. May nangyayaring flood control scandal, may nangyayaring gulo sa Team Unity na hindi na united ngayon. we consider Senator Marcoleta and Senator Jinggoy political prisoners, weaponized yung Blue Ribbon Committee at weaponized yung ano. So Mr. President, hindi tama na sabihin na I wasn't, after we brought up the problem with NBI, they doubled down, naggumawa pa ng task force. I mentioned 2 colleagues sa Salian, I didn't accuse them. Sabi ko lang, just like Vice President Sara, just because tumaas ang Salian, can we already ask for the BIR, for the AMLA and the bank accounts? So sabi ko, yan ang i-discuss namin sa Monday. Nag-react na, nag-accuse. I did not take up your accusations here today. Si Secretary Vince Dizon, 3 beses na nag-verify sa Taguig. Sinabi na 3 beses na walang ghost. Ngayon, i-verify ulit. I wasn't going to bring that up, but then i-question ninyo si Senator Padilla. It was all over the news na hindi niya inintindi or he snubbed the ombudsman. I was going to stand up before Senator Erwin stood up just to say, may registered mail. So nung una pa lang, 5 minutes si Senator Tulfo, so I'll take the 5 minutes also if you don't mind.
The gentleman may proceed and kindly be mindful of the time.
Yes, I will now. So I'm just saying, Senator Padilla just stood up to say, sumusunod siya sa batas. Tapos, kaya humaba to dahil nga hindi importante ata dito yung integrity ng judge. Lastly, kaya sinabi kong it's useless to argue a legal point. Ilang beses ko na narinig dito. It's our job to clear or prosecute the Vice President. Hindi po. It's our job to try and to decide. It's the prosecution's job to try to prosecute, and it's the defense job to convince us na wala. Our job is to try and to decide. And when you decide, you acquit or you convict. Why is that important? These are legal terms. Hindi pwedeng yung nanonood na law student ngayon sasabihin, trabaho pala ng judge to clear or to prosecute. Thank you, Mr. Presiding Officer, Mr. Senate President.
Thank you, Senator Judge Alan Cayetano. His remarks are noted. Senator Judge Soto, thereafter, Senator Judge Padilla, thereafter, the presiding officer shall make a ruling. You may proceed, sir. You have 2 minutes.
Yeah, thank you, Mr. President, the presiding officer. I do not have 4 years of law, but I have 29 years of lawmaking. And I move that the manifestations of that we have heard be referred to the Senate proper.
We will act on it at the proper time, Your Honor. Thank you. Your remarks are noted. Senator Judge Padilla is recognized. You may proceed, sir. You have 2 minutes.
Maraming salamat po, aming tagapamahalang hukom. Ito pong kasuotan natin sa mga oras na ito, hindi lamang po ito nire-represent ang impeachment ng ating pangalawang Pangulo. Ang nire-represent po nito ay ating karapatan bilang mga Pilipino at unang-una na ang due process. Ito po yun ang ibig sabihin. Kaya ikaw ay pangalawang Pangulo, ikaw ang Pangulo, ikaw ay Senator Judge, ikaw ay magsasaka, ikaw ay mangingisda, kailangan may due process. Yung pong nangyari sa akin, na ako po ay nahusgahan na kagad bilang Senator Judge, ang pinaglalaban po natin integridad ng korte na ito at ng mga Senator Judge. Kaya sana po wag nating kalimutan na ang bawat Pilipino ay may karapatan, lalong-lalo na sa usapin na ako sa oras na ito ay Senator Judge. Yun lamang po, napakaiksi lang. Due process, mga mahal kong kaibigan, mga mahal kong kababayan, maging prosecution, maging defense, sa ating lahat, huwag nating kalimutan. Pantay-pantay tayo sa batas. Maraming salamat po.
Senator Judge Pangilinan, what is your pleasure, sir?
Yes, just a very quick manifestation, Mr. Presiding Officer. Earlier, former Senate President Soto moved that these matters be referred to the Senate. This is precedent actually. During the Estrada impeachment trial, the father of Senator Cayetano, Alan, Senator Rene Cayetano, made a manifestation regarding a case that was supposedly being prepared a criminal case to be filed against him. It was raised in the impeachment court, but ultimately the impeachment court agreed that the manifestation was referred to the Senate as a legislative body. So there is precedent for this. Yes, the court allowed then Senator Rene Cayetano to make his manifestation, but eventually it was resolved that the matter be referred to the Senate as a legislative body. So we share, we move for the previous, yes, we call for the previous question, Mr. President.
Senator Judge Cayetano.
I think the presiding officer ruled that we will take it up later on, but if Senator Judge Pangilinan will insist, then I have to object on a point of order. Rule 6 says, the last part, the provisions of the rules of the Senate and the revised rules of court shall apply suppletory whenever applicable. And in the rules of the Senate, whenever the senator feels threatened or anything happens, whether pinatayan ng aircon, whether may nakatutok na barel or sinaran ng pinto, he can rise on a point of personal and collective privilege. We didn't do that para umikli. Now, if we're going to argue today rather than ask them about due process with a simple manifestation from Senator Padilla na hindi totoong binabastos o binabaliwala ang ombudsman, registered mail lang kaya hindi pa nadagdag. So, hindi kami ang nagwe-waste ng time. We can have a caucus, we can talk about it. You want to debate that now?
With the permission of Senator Judge Pangilinan, to abbreviate the proceedings,
May I just, Mr. President, because I was alluded to, Mr. President. May I just very quickly, Mr. President, Rule 6 on...
you may proceed, sir.
Thank you, Mr. President. Rule 6 of our impeachment rules, Mr. President, which was quoted by Senator Cayetano as being suppletory. Mr. President, that refers to evidence, rulings on evidence in the impeachment trial. It does not refer to privileged speeches. Therefore, the suppletory nature of the rules of court as well as the Senate rules refer to matters pertaining to evidence and no other, Mr. President. But in the spirit of liberality, we will allow that. That's precisely why we did not object when he spoke last week. But let us not abuse the liberality of this court, Mr. President.
With the permission of Senator Judge Tulfo Erwin, the chair will make a ruling because I believe it is also his position not to prolong this matter in discussing collateral matters not pertaining to the articles of impeachment that we are hearing and trying before the impeachment court. The chair rules that the manifestation of Senator Judge Padilla shall remain in the records. We cite as a precedent the precedent mentioned by Senator Judge Pangilinan, where the speech of the late former Senator Rene Cayetano was not expunged from the record, but referred to the Senate as a legislative body, where it may be. I ask the indulgence of the parties to this case. Wala po kasi kaming session. Ito lang po ang pagkakataon na nakakapagsalita at nakikita-kita kami habang recess kami. Pero umaasa ako, within hearing distance of my colleagues, na kapag nag-resume na po ang Senado sa susunod na linggo matapos ang sona ng Pangulo, may pagkakataon na po ang bawat miyembro ng Senado bilang senador, hindi bilang senator judge, na may labas yung mga hinaing o anumang nais nilang sabihin kaugnay sa anumang nagaganap o nangyayaring hindi tama sa kanila o ginagawa laban sa kanila. And that, I think, is the proper forum for us to ventilate, discuss, look into, and if necessary, investigate the and or accusations against senator judges in their capacity likewise as senators. So ordered.
Officer.
What is the pleasure of Senator Judge?
I will just manifest, I correct myself, it was stamped, not registered mail. And since I agree with the ruling, I will not anymore argue the other rule that correlates with Rule 6. Thank you.
Thank you, sir. Noted that it was stamped. The Senate President, thereafter, Senator Judge Erwin Tulfo.
Thank you, Mr. Presiding Officer.
Hopefully we can move on after the manifestations of the gentlemen.
Let me appreciate and thank the ruling of the presiding officer to refer the manifestations as well as the comments of our colleagues to the Senate, acting as a legislative body. 8 days na lang po ay magko-convene na ang Senate at doon rin ho natin pag-uusapan itong mga mahalagang bagay na pag-usapan ho natin ngayon at kanina po ay narinig ko po yung komento ng ating kasamaan si Senator Romy Padilla at ito po yung mga bagay na dapat rin po nating talakayin pag nagbukas na po ang Senado in 1 week's time. So with the indulgence of our colleagues, importante ho yung oras ng trial sa mga darating na panahon. Nasabi ko nga nung mga ilang araw na mahaba pa yung ating dadaanan. Ito ay 7th day pa lang out of the 102 days na dadaanan ho natin. Kaya bawat oras, bawat segundo ay napakalaga. At nagpapasalamat po ako sa ating mga kasamahan dahil po sa kanilang masusing pag-participate ho dito sa ating impeachment. Pero dadating rin po tayo doon sa pagtatalakay nitong mahalagang issue pagbukas po ng Senado. Maraming salamat, Mr. Presiding Officer.
Senator Judge Erwin Tulfo, briefly, sir, so that we can proceed to the matter on hand.
Very quickly, Mr. Presiding Officer, can we start now, sir?
I was about to, sir.
Thank you, sir. We wasted 26 minutes for nothing. Thank you po.
Proceeding now to the matter on hand. The presiding officer already made the ruling, referring it to the Senate as a legislative body, Senator Judge Soto. Without expunging it from the records, let it remain there. We will now proceed on the matter at hand. We now resume consideration of the prosecution's requests for the issuance of subpoenas duces tecum number 1 for the banks and the Anti-Money Laundering Council on the other, on one hand, and to the Bureau of Internal Revenue on the other. And as previously agreed and discussed, not only in caucus but also directly by the presiding officer with some members. Chair will now recognize, as I understand, Senator Judge. Ikaw ba una? Senator Judge Alan or Senator Judge Villanueva or Senator Judge Pia? Who would want? No one's raising their hand. That's why I don't know. Senator Judge Villanueva is recognized. You may proceed, sir. Thereafter, Senator Judge Pia Cayetano. Thereafter, Senator Judge Alan Cayetano. You may proceed, sir.
Thank you, Mr. President. Thank you, Mr. Presiding Officer. As much as I am more than willing to give way to our dear colleagues. But Mr. President, before I make I inquire and pose some questions to the prosecution and the defense, may I also raise something, Mr. Presiding Officer? Gusto pong malinawan tungkol po dun sa procedural aspect, Ginoong Pangulo, dun sa motion na ito. Kasi sa regular courts, hindi naman po unusual na ang isa pong motion ay i-grant in part at i-deny in part. Depende po sa legal and fact basis ng bawat relief na hinihingi po, Ginoong Pangulo. So, pwede ko po bang malinawan lang, Mr. Presiding Officer, tama po bang sabihin ganun din yung kapangyarihan ng ating impeachment court? Maaari po ba na suriin ang bawat hinihinging sabina ng magkahiwalay at magpasya po batay sa legal at factual basis ng bawat isa sa halip po na tratuhin ang buong motion bilang isang all or nothing proposition?
Tatratuhin ng hukumang ito bilang nag-iisang motion ang tag-isang motion na inihain ng prosecution. They only filed 2 motions, Senator Judge Villanueva, and the court will act on these 2 motions separately, regardless of the number of issues or sub-issues underneath each motion. The reason is simple, because the court should be a passive body. By amending the motion into several parts and voting on it separately, we are essentially acting as if we were one of the parties in voting for or against the grant of the motion, we should take into consideration all of the factors that may be raised for or against it. And it may be cited by the senator judge in explaining his vote or voting for or against it. Pangalawa po, bilang mga hukom, hindi tayo pwedeng masyadong aktibong makilahok sa paraan ng mga motion which is essentially a relief being asked for by a party sa pamamagitan ng paghahati ng mga motion na yun para pagbotohan ng hiwa-hiwalay. And there is precedent insofar as this position taken by the presiding officer is concerned. In the impeachment of the former Chief Justice, late former Chief Justice Corona, where then Senate President, presiding officer Enrile ruled that the ruling of the chair on motions are indivisible and may only be appealed in toto and not in part.
Thank you, Mr. Presiding Officer. And it's clear to me now, despite the fact, Mr. Presiding Officer, Your Honors, that if there would come a time na, for example, sa isang sabina, may sinasabina na sa asawa o sa korporasyon na hindi naman relevant at material doon sa kaso, yun lang po, Ginoong Pangulo, ang ating nagiging reservation tungkol po dito. Ngunit naging malinaw po sa akin na magiging isang desisyon lamang doon sa dalawang motion na inihain.
Tag-isang desisyon kada motion, pero pwede, gaya ng nasabi ng kagagalang-galang na hukom na senador, na pwedeng hindi ibigay yung lahat ng korteng ito. Pwedeng iba lamang, parte lamang, at hindi eksakto ng hiningi niya. Pero yun ang pagpapasyan na bilang isang nag-iisang motion.
Marami po salamat. Naging mas malinaw po sa kinatawan na ito ang ruling ng ating presiding officer. May I start raising some questions, Mr. President, Mr. Presiding Officer, to the two parties, Mr. Presiding Officer, just for the guidance of the court, and I think it's important that we distinguish between two separate procedural questions. Una, kung dapat po bang i-produce ang hinihinging records, at pangalawa, kung ang mga records na iyon ay magiging admissible, at kung anong evidentiary weight ang dapat ibigay sa kanila. So let me start by asking our lead prosecutor, Congressman, to our dear Congressman, would it be correct, sir, to say that the issuance of a subpoena merely compels the production of records and does not by itself amount to a ruling that those records are admissible, relevant, or entitled to evidentiary weight, Your Honor?
Before the member of the panel for prosecutors answers, he's not the lead prosecutor. The
sorry.
question is addressed to the Honorable Representative Chel Jokno, who is a member of who is part of the panel of prosecutors who will be answering your questions. And for the record too, on the part of the respondent, I think it's Attorney Poa who will be answering.
That's correct.
So that we don't need to identify each one each time anymore for the record. The Honorable Jokno may respond to the question of Senator Judge Villanueva. You may proceed, sir, when you're ready.
Thank you, Your Honor. Good afternoon to all the members of this honorable court. Naisagot na po ata yan ni dating presiding Judge Juan Ponce Enrile dun po sa Corona impeachment case. And if I may quote just a brief portion from what he said, I would like to explain that the resolution of this court was simply to authorize the issuance of a subpoena. And whether those evidence subpoenaed are admissible evidence, given the fact that they apparently appeared in violation of existing laws, is a question that must be resolved in due course. So ang ibig po sabihin, ang hiling lang po ng prosecution ay mailabas ang ebidensya, pero wala pa po tayo dun sa punto kung tatanggapin ba nitong hukuman ang evidence na yun, kung siya po ay admissible o hindi.
Maraming salamat po sa inyong tugon, Representative Jokno. Kaya po, nilahad ko po yan nang sa ganoon, maitanong po natin ang defense panel if that distinction is correct, would the defense still maintain that the mere issuance of a subpoena is by itself already prejudicial to the respondent even before the court has ruled on admissibility or weight?
Yes, Your Honor. Good afternoon, Honorable Senator Judges. Yes, while we agree with the position of the prosecution na hindi pa naman pinag-uusapan ang admissibility sa puntong ito, what we are questioning is really yung subpoena mismo po. Dahil sa ating pananaw, ang isang subpoena, at hindi lang sa ating pananaw, but even under jurisprudence, meron pong requirements bago tayo makapag-issue ng subpoena para maging valid yung subpoena na yun. At yun po yung napag-usapan natin nung nakarang linggo na definiteness and relevance. Ngayon, yung twin requirements na yun para po sa pananaw ng depensa ay lacking in this case. And that is why we maintain our position as regards opposing itong request ng prosecution sa pag-issue ng subpoena.
Well, at least malinaw po, ang pag-issue ng subpoena, not necessarily opening of records, una. Pangalawa, to be presented in court. At pangatlo, to be admitted as evidence by this court. Before I go dun sa requirements, let me ask the panel of prosecutors, si Representative Jokno, dun po sa pananaw ng depensa on alleged fishing expedition, just for the guidance of Senator Judges, this representation would like to clarify one procedural matter. We understand that the concern raised by the defense that the subpoena may be overly broad. And at the same time, we also recognize that the court has a duty naman to determine whether the records being sought are sufficiently relevant and material to the issues before us. So, Representative Jokno, maaari po ba ninyong ipaliwanag kung paano ninyo tiniyak na ang hinihinging mga records ay hindi po simpleng paghahanap lamang ng posibleng ebidensya o tinatawag na fishing expedition, kundi ito po ay mga partikular na dokumento na sa tingin po ninyo ay meron pong malinaw at direktang kaugnayan dito po sa mga articles of impeachment.
Thank you, Your Honor. Ang hinihiling po namin sa mga subpoena ay kaugnay sa Article 2, which involves charges of unexplained wealth. Kung titingnan po natin yung mga jurisprudence pagdating sa unexplained wealth, klarong-klaro po na sinabi mismo ng Korte Suprema na kailangan makita yung buong larawan, hindi lamang po ng mga salin na final ng isang lingkod bayan, kung hindi lahat ng kanyang kinita, both what we would call lawful and, if there is, illegitimate income. Ang salin po kasi ay parang snapshot lang po yan, year-end, kung ano yung mga assets, liabilities, and net worth ng isang government official. Ang ITR din po ay parang short video lang po yan ng mga transaksyon ng isang taxpayer sa kabuuan ng taon na yon. Makikita lang po natin yung buong larawan pag nailabas natin ang mga bank records. Kasi doon po yung day-to-day na lumabas at pumasok sa isang account ay mabubuo po natin. And in fact, in the case of DOF Rips versus Merencilia, ito lang pong portion ang babasahin ko. Sabing ganun ng Supreme Court, the failure of the complainant to take into consideration respondent Rafael's net worth from the time he entered government service and the failure to take into consideration all of his possible sources of income in relation to his real and personal properties do not support the conclusion that he has unexplained wealth, considering that his true net worth was not determined. Ito po ay sabi ng Supreme Court, Ombudsman, hindi nyo nagawa yung inyong trabaho. Kaya ayaw po namin tumulad sa nangyari kay Ombudsman dito sa kasong ito. We want to see the entire picture. Kaya po namin hinihingi yung BIR records, pati yung mga bank records, and even the Anti-Money Laundering Council records para makita po natin yung buong story as far as both the assets, liabilities, and net worth are concerned, and the lawful and if there is unlawful income acquired by the respondent.
Last question no, sa prosecution. No? Sir, binanggit po kanina nung the defense panel yung requirements which should be relevant and specific and kinikilala po natin dito sa korte na yung subpoena is an important tool na available po dito sa impeachment court in the search for truth. Pero kinikilala din po natin na ang mga records na ating hinihingi ay may tinatawag na statutory protection under our laws. Now in this regard, Your Honor, bago po ninyo hiniling ang compulsory production ng mga confidential records na ito, may we know what led the prosecution to conclude that the issuance of subpoena is the least intrusive and most appropriate means of obtaining the information na sought. In other words, Your Honor, paano po ninyo masasabi na itong subpoena is not only relevant but also necessary and proportionate under these circumstances?
Ang subpoena po ang tanging paraan para makuha ng nitong hukuman ang mga kinakailangan po natin na datos at informasyon at dokumento. At hindi naman po siya intrusive dahil tulad na nabanggit ko po kanina ay
the subpoena. There is a distinction between an authorized disclosure and production pursuant to a lawful order of a constitutional body. So again, my question, Your Honor, where exactly in Section 8A, the AMLC may refuse a lawful subpoena from this court, Your Honor?
Thank you for that question, Your Honor. Unang-una, sagutin ko lang po yung pretense ng inyong tanong. No? Sabi nyo, this is a constitutional body, hindi po ba? And as we all know, there is an old legal maxim that the spring cannot rise over the source. No? Ibig sabihin po nun, while the impeachment court is a constitutional creation, it cannot go up over and above the Constitution itself. And when we talk about the impeachment court under Article 11, we cannot read that in isolation. We have to also give due regard for all other provisions of the Constitution, specifically the Bill of Rights, kung saan due process no, ay na nakatatak po doon. At pinapakita doon, ano bang ibig sabihin ng due process? Due process is, kasama po sa kalakip ng due process, ay ang bawat na nasasakdal ay meron ding pribilehiyo na maging maprotect o maproteksyonan ng mga batas na isinagawa ng mismong Kongreso. So now let's go on to Section 8A. No? As you can see, Your Honor, that is at least for our position, it's an absolute prohibition. Unlike other laws where they created, for example, secrecy law, meron nakasulat doon, aaminin natin. In cases of impeachment, is an exception. Pagdating po dyan, wala po ni isang exception. It could have been easy, especially since this is a 2021 amendment. No? It could have been easy for Congress to have cited impeachment as an exception if it did actually wish to do so. But it did not, Your Honor. And it is our position that if we were to compel and issue a subpoena against these AMLAC records, we're actually compelling the officials to violate this very section of the law. And that is why we are saying na pagdating sa 8A, absolute po yan. It does not say that there's any exception if any court processes are actually issued to compel the production of these documents. Precisely because ang nasa loob po kasi ng mga records ng AMLAC are intelligence. No? And that's why it's confidential. And once AMLAC determines that they find out that certain transactions are subject to money laundering or should be actually filed in court, the end result is the complaint itself and not the raw data. And that is why, Your Honors, as to the raw data or the information that they receive, yan po ay strictly confidential under 8A.
Thank you for that. Again, I would like to put on record that I was trying to look at that particular section 8A, and I don't see anything that says this court would not have any prerogative as to whether or not we can subpoena bank records. But let me move forward. Perhaps this could be my last question, Your Honor, Mr. Presiding Officer. The Constitution recognizes two equally important principles: confidentiality on one hand and the freedom of information. It promotes transparency and public accountability on the other. So, Attorney Poa, gusto ko lang pong malinawan for the benefit of this representation and our dear colleagues here, being senator judges, may legal distinction po ba between disclosure of information to the general public and the limited production of records solely to this impeachment court in the exercise of its constitutional function? Because we understand that the principle of freedom of information is rooted in transparency and public accountability, especially po when the conduct of a public officer is under constitutional scrutiny. Now, if confidentiality is the concern, would you agree, Attorney Poa, that this impeachment court can impose safeguards on the use and disclosure of the records? Kung maaari lamang po, kung maaari naman po na magpatupad ang impeachment court ng sapat po na safeguards upang mapanatili ang confidentiality ng mga records, bakit po dapat maging hadlang ang confidentiality sa isang impeachment court upang suriin ang mga impormasyon na maaari nga pong may kinalaman sa mga isyung nararapat nitong resolbahin bilang isang impeachment court?
Para atin po, no, kung ano man pong hakbang ang pwede o hindi pwedeng gawin ng isang impeachment court tulad ng nasa harap natin na ngayon, it must be confined to the limits imposed by the Constitution and the laws. No? So kahit sabihin po natin, we are not against transparency. I just want to make that clear, Your Honors. We are not against accountability. But again, as I've mentioned last week, hindi naman porket po that we are all looking for accountability at transparency, ay isasantabi na lang po natin kung ano ang mga karapatan, hindi lang para sa impeachable officer, pero para kahit sinong Pilipino na nakasaad sa batas, including absolute confidentiality in terms of AMLAC reports, which we are pointing to. So para po sa atin, nakikita ko yung punto po ng ating hukom, no, na paano kung mag-impose na lang tayo ng certain conditions. However, Your Honors, those certain conditions may be allowed for other records, pero pagdating sa AMLAC po, absolute po kasi yung prohibition. And if we were to amend or at least suspend the provision of 8A, then it is as if this honorable court is actually doing some sort of judicial legislation, no? Because we are technically suspending this law for a specific person na hindi natin pwedeng gawin sa iba. That is why ang sa akin lang po, ang sa amin sa punto ng depensa is paano po yun? Meron po pang instances na papayagan na lang natin, isang tabi natin yung batas at merong instances na hindi. I think, Your Honors, we feel, the defense feels, Your Honors, that in the search for truth, transparency, accountability, we must still work within a framework, which means that we must work within the limits imposed by the Constitution, the laws, and the rules of the land.
Salamat po, Attorney. Mr. Presiding Officer, just a few seconds just to put on record. Ang Senado po ay nasa plenaryo na po yung proposed Bright Act natin na maraming sumuportang mga kasamahan natin. And ito kasama po dito yung amendments to AMLA to put in black and white the circumstances under which bank records, financial transactions may be lawfully accessed by competent authorities. Subject always, of course, Mr. President, to appropriate safeguards and due process. So gusto ko lang pong banggitin that indeed confidentiality is an important legal protection, pero hindi din po ito dapat maging dahilan naman para manatiling mailap po ang pananagutan. Ang mabuting batas ay kayang pangalagaan ang privacy nang hindi po nasasakripisyo ang accountability. Our laws must be able to protect both. Mr. President, Mr. Presiding Officer. Maraming salamat po, Ginoong Pangulo. Maraming salamat po, our council. Thank you.
Thank you, Senator Judge Villanueva. Your remarks and responses thereto are duly noted and entered into the records. Senator Judge Pia Cayetano is next, I believe. You may proceed, ma'am, when you're ready.
Hindi na ako
I'm ready to proceed, Mr. Presiding Officer. I'd like to start this discussion with a question that hopefully will allow our kababayans who are watching, listening, to understand the situation. Of course, I pose it also to the parties. If the government had in mind that there's a business and of course a particular businessman or businesswoman who is violating a lot of laws pertaining to the operation of their business, be it customs law, BIR, regulations, can they just proceed and pwede ba silang basta na lang mag-request ng dokumento o mag-file ng kaso na requiring the businessman and the corporation to produce those documents? Pwede ba? So yun ang pag-isipan natin, no? Kasi yun ang tanong eh. Similarly, ginagawan ko lang ng ibang analogy para maintindihan mga kababayan natin. So this is the essence, dear colleagues, parties, of the principle of due process. This is ingrained in our Constitution. Totoo po na may karapatan ang gobyerno at obligasyon ng gobyernong patakbuhin ng maayos ang gobyerno. But it is always with due respect to the rights of every individual Filipino. That is the right to life, liberty, and property. So bago mo sagasaan yung right to life, liberty, and property, siguraduhin mo lang na may basehan ka. Yun lang naman ang sabi. So of course ako, gusto ko talaga na maayos ang patakbo ng gobyerno para if somebody's life is also in danger, then government has to step up and prevent somebody's liberty. Kasi nga, sinasagasaan niya yung life and liberty ng ibang tao. So it's a balance. No? I think we can all agree it's a balance. So I want to go straight into a landmark case and I will ask both parties for their legal opinions on it. Kasi it is a legal proceeding. Pero gawin nyo lang simple para hindi masyado complicated para sa mga nakikinig sa atin. So in the landmark case of Stonehill versus Diokno, 1967 pa po to, karamihan ng mga lawyers hindi pa pinapanganak. The importance of due process was highlighted and the Supreme Court discussed 2 points. General warrants are void. Sabi ng Supreme Court, a warrant must be issued on probable cause for one specific offense and must particularly describe the thing being seized. So kailangan particular ang description dun sa warrant. Warrants that leave it to the discretion of the officers serving them to decide what to seize or general warrants are outlawed by the Constitution because they place the sanctity of the home and privacy at the mercy of prosecutors. So sinabi dito na kailangan specific. Take note warrant ito ha. Supina naman ang pinag-uusapan natin. Alam ko po yun. Pero I'm pointing it out kasi ang magiging tanong ko later on is kung relevant ito sa kaso. Okay? The other principle that was established in Stonehill versus Diokno was the exclusionary rule. Evidence obtained through an unconstitutional search is inadmissible for any purpose in any proceeding. Ito po yung tinatawag na the fruit of the poison tree. Pag nakuha mo yung information dun sa bawal na paraan, kung ano yung information mo, bawal ipakita yon. And this is where I need to get guidance from the presiding officer. If I'm allowed, I don't have to name names, to share the discussion that we had in caucus para lang mabanggit ko na ito yung mga provisions of law na napag-usapan. Am I allowed to do that? Would you like me to approach you? Please let me know because I will abide. Basically, because ang nangyari is we had our own discussion and I want to mention the provisions of law that we discussed. I don't have to mention names.
The lady may proceed.
Okay, thank you. So, tungkol dito sa exclusionary rule, ulitin ko, fruits of the poison tree, dun nga sa aming very open discussion, and I thank many of our colleagues who were I think we engaged in a fruitful discussion for some, not for all. I think yung iba talagang gustong makipag-debate at di-debate kasi gusto ko rin matuto, no? I think all of you will attest na I also wanted to learn from all of you kung anong perceptions nyo sa batas, kung ano din yung sinasabi ng mga abogado nyo. So dun sa fruits of the poison tree, sabi ko, kung yung pinanggalingan ng mga dokumento bawal na kunin ng basta-basta, then paano mo gagamitin? And meron kasing observation na lumabas na kasi yung documents na yon sa House. So nakita na ng publiko sa House. So sabi ko, pero if I will look at, and this is where I will pose the question to all of you, no? Medyo layered so pasensya na sa medyo complicated. Yung isang concern ng defense na nabasa ko is that hindi nag-allege ng ultimate facts. Hindi klaro kung ano yung naging kasalanan at hindi na-identify ng maayos itong facts na to that lead to a conclusion of law. So wala daw yun. Later on, I will ask both parties again to also clarify that. But the point is, kung walang basihan yung paglabas ng ebidensya na yon, it is the fruit of the poison tree, then you cannot use it. So yun yung importante dito kasi I'm sure nakita nyo no sa korte kahit sabihin nyo pong sa mga legal drama na na-throw out. The case is thrown out because na-violate ang due process. So that's the discussion I want to have. I want to hear both ha. Wala akong kinikilingan dito. I'm just explaining na yun yung argument ng defense na walang due process, kulang at why prosecution would you say na nasusunod yung due process. And before I give the floor to the parties, yung sinabi kong kaso na Stonehill versus Diokno, very interestingly, involves the esteemed father of our colleague, Congressman Prosecutor Chel Diokno. In the case of Stonehill versus Diokno, the father of Congressman Diokno was the Secretary of Justice. And in this case, the government, through the Secretary and other prosecutors, suspected that Harry Stonehill and his associates and several corporations that they controlled were violating central bank laws, tariff and customs laws, Internal Revenue Code, and the Revised Penal Code. So nag-request sila ng issuance of search warrant. At ang gusto nilang tingnan is books of accounts, financial records, vouchers, receipts, ledgers, etc. and other documents showing all the business transactions. Stonehill and the other petitioners filed a petition before the Supreme Court arguing that the search warrants were general warrants because they did not particularly describe the things to be seized. So, general pa pala yun. Books of accounts, financial records, receipts. General pa pala yun. And the Supreme Court ruled that indeed, general warrants are void. Warrants must be based on probable cause. Nasabi ko na yun, ano? And then the case also adopted the exclusionary rule, holding that evidence seized under an unconstitutional warrant is inadmissible. So, I now pose my questions. Applicable po ba ang kaso na ito, Hill versus Diokno, as far as the prosecution is concerned, and then also for the defense applicable. Take note, I've read most of the pleadings. Well, all of the pleadings, mahahaba sila. I kind of know your answer, but sa dami, I like to hear it again, and I think, of course, karamihan ng kababayan natin did not read it. So explain natin sa kanila, because this is a landmark case. Kung ikaw ay law student na magbabar, ito yung mga kasong titingnan mo. So malay mo, matanong yan sa bar. So nakatulong man lang tayo dun sa mga bar students na maliwanagan sila. Baka mamaya trick question to. Is it applicable or not? That is my question. I will sit down and then I will come back for my next. Thank you.
Thank you, Your Honor. If I may be recognized.
The member of the panel of prosecutors may proceed to give his answer. Thereafter, the counsel for respondent may do so as well.
Iba po ang konteksto ng search warrant na naging main issue sa Stonehill versus Diokno. Sa konteksto po natin na subpoena ang pinag-uusapan. Ang search warrant po, ang governing law po dyan ay nasa Bill of Rights natin, Article 3, Section 3. At kaya siya nandun dahil very invasive po ang search warrant. Pag ang isang judge ay nag-issue ng search warrant, pwedeng pasukin yung opisina o yung bahay ng person involved, pwedeng halongkatin yung lahat ng mga gamit niya doon sa kanyang opisina o sa kanyang bahay. Kaya po naglagay ng maraming limitasyon ang ating konstitusyon dahil marami ng pang-aabuso, marami ng mga halimbawa ng pang-aabuso na nangyari kahit noon pa. Iba po ang pinag-uusapan natin ngayon. Ang pinag-uusapan natin ngayon ay subpoena. Hindi po ito a license to enter an office or to search any place. Ito po ay mismong humihiling lang ng mga dokumentong nakasulat sa loob ng subpoena. Therefore, the contexts are very different. When we speak of a search warrant, I do agree there should be very specific limitations on how that warrant can be enforced. Pagdating naman po sa subpoena, meron din po yan, but that is not governed by the Constitution. It's governed by Rule 21 of the Rules of Civil Procedure, which basically provide that for a subpoena to be valid, it must be relevant and it must be definite. Ibig po sa relevance ay may kinalaman na may kaugnayan yan sa mga kailangan patunayan ng mga facts. At pagdating naman sa definiteness ay klaro kung anong mga iba't ibang dokumento ang hinihingi. In our case, we respectfully submit, Your Honors, that we have met both the standards of relevance and materiality. The BIR records, the bank records, and the records of the Anti-Money Laundering Council are relevant to the facts in issue pertaining to the charges of unexplained wealth. Hindi po natin malalaman kung talagang merong unexplained wealth ang Vice President kung hindi natin mabubuksan yung kanyang mga bank records, kung hindi rin natin makikita at mailalatag ang anti-money laundering at BIR records po nila. And insofar as definiteness is concerned, we have specified the particular documents that we are requesting, and we have included as well an explanation of why those are important. Kaya sa aming pananaw po ay we have satisfied the requirements for a subpoena to Sesteco. Thank you.
Mr. Presiding Officer, before we recognize the defense, just a quick follow-up question.
Hindi ko may lapit eh.
Bigyan ko ng time na bulungan muna siya ng kasama.
I'm sorry.
Okay na kayo? No, it's okay.
Senator Judge Pia, would you like the counsel for respondent to answer?
Not yet, Mr.
Not yet,
My
okay.
request was if
Okay.
I'll just ask a follow-up question.
You may proceed, ma'am.
Thank you for that. I appreciate his honor's response. May I simply point out, and again, please give me your explanation. Tama ho yung pagkabanggit nyo na yung nature ng search warrant very invasionary, di ba? Because it requires that pasukin yung bahay, halugugin yung gamit. Pero hindi kaya invasive din yung paghalughog ng records? Is that not extremely parallel? I mean, is it not very similar in the sense that what is being questioned now are the very essence of somebody's savings, earnings? So, which we have to agree, I think there's no doubt that that is protected, but in fact, His Honor is saying that it would fall under the police power. So, imbis na papasukin mo sa bahay na nandun yung mga dokumento, You will do the same by asking these agencies, whether it is the BIR, the banks, or AMLA, to now reveal these documents. So that's my question. Is it in the prosecution's, is it the point of view of the prosecution na iba yun? Hindi ba invasive yun? Kayo gumamit ng word na invasionary, no, but I'll use invasive, I think. Yeah, anyway, please answer, and then we'll give the floor to the defense, Mr. Presiding Officer.
Counsel for the panel for prosecutors may
Thank you, Your
answer as he pleases.
Yung pong search warrant, kung ano man ang makuhang ebidensya doon, ay direktang binibigay po yun sa court, and that is now considered as evidence by the court that issued the search warrant. Iba po ang subpoena, dahil pag naglabas ang isang hukuman ng subpoena, itong mga records ay hindi po siya considered yet as evidence. Yan po ay ipoproduce lang, dadalhin lang po sa korte, and now it is up to the parties, and I refer to both parties, to decide which of those documents may be relevant in terms of the evidence that they need to present. Yung pong nakikita po natin sa subpoena, it is not in any way invasive because, as I mentioned earlier, and as pointed out by Senator Enrile when he was the presiding officer in the Corona trial, we are simply having those documents produced. The admissibility of those documents will only be determined after if offered by the parties. Kaya po sa aming mga pananaw ay malaking-malaki ang pagkaiba ng search warrant sa subpoena.
Your Honor, may I be...
With the permission of the lady Senator Judge, counsel for respondent may now give his answer to her query. You may proceed, sir.
Thank you, Your Honors. Your Honors, ang posisyon po ng depensa dito ay subpoena and a search warrant are very much similar in that both are compulsory processes. So, yes, hindi tayo papasok sa bahay ng isang tao o ng nasasakdal, but it will be intrusive because we will be opening up all the financial transactions for sabi nga dito, almost 20 years of the respondent. Kaya po, katulad ng isang search warrant, the things that we are asking for through a subpoena must be particularly described. Kanina po, nabanggit po ng aking kagalang-galang na opposing counsel na particularly described na po yung kanilang naisulat. However, the defense does not agree with that proposition because if you look at it, tama naman po, nakasulat po dito ng hinihingi nila ay account opening and maintenance records, KYC documents, information files, signature cards, all account and transaction records, ledgers, journals. Basically, Your Honors, this is everything. Ibig sabihin, ni-specify lang nila ang nilalaman ng lahat ng bank records ng respondent. So in our view, Your Honors, while they took pains to specify each and every document, the truth of the matter is they're asking for everything. Ngayon, pagdating sa subpoena, and even in the case they cited, yung Rocco versus Contreras, no? Nakasulat po doon that for a subpoena to be validly issued, when we talk about particularly describing yung kung ano yung hinihingi, it has to be evidence that is both relevant and material. So ang tanong namin, saan ba dito yung relevant or material? Kasi lahat na po ng records hiningi eh. So, and this bolsters our theory, of course with all due respect to the opposing side, na kaya namin tinatawag o kaya namin natawag na fishing expedition ito. Kasi lahat na ng records hiningi, pero hindi naman matukoy which would actually be relevant, which would actually be evidentiary to the accusations they have made under the articles of impeachment. So, pero dito, hinihingi natin 20 years worth of records. And then, paano po yun? Hihimayin natin, maghahanap tayo ngayon kung may relevant o wala. Which brings me back to yung BIR records. Nakaseal po yung box. So, I would say, both parties, hindi natin alam kung anong nasa loob nun. Yet, we're hoping na somehow, pag nabuksan yung box na yon, meron po tayong makikitang ebidensya. And that's why, again, with all due respect, we called it a fishing expedition. Kasi hindi naman na-identify kung ano mismo doon yung pwedeng ebidensya laban sa sinasabing unexplained wealth umano ng Vice Presidente. So, with the question, for us, yes, the Stonehill case, Stonehill versus Diokno, directly applies to the current proceedings. Kasi nga po doon, sinasabi talaga na dapat specified yung hiningi, particularly described and relevant. But as of this point, they're asking, Your Honors, for all of these things. And again, while they specified each and every document, kung babasahin niyo po ng mabuti ito, they're actually asking for all bank records without, in fact, telling us which transaction is relevant to their accusation, which transaction will actually support their accusation. Yun po yung aming pananaw dito sa tanong ng ating kagalang-galang na hukom. Thank you po.
If Your Honor, please may be allowed to respond.
Hold on, counsel for the panel of prosecutors. Senator Judge Pia is the one asking the questions. Unless it's not a debate between the two counsels, you're merely responding to answers from questions by senator judges.
I actually prefer not, pero alam mo na, baka sabihin naman na may bias tayo pag di ko naman pinayagan. Di payagan.
no,
I defer to
Senator Judge Pia, you asked the question, they answered. It is not for the opposing counsel to answer points raised. They had that chance when they did their oral arguments, rebuttal and surrebuttal. You may proceed with your question, Senator Pia.
Sige, my question is, what is your question? Or what is your comment? Go ahead. But keep it brief. Keep it brief.
Thank you so much, Your Honor. I just wanted to point out that this is the first time actually an impeachment court is faced with the challenge of determining whether the charges of unexplained wealth are valid or not. And yung previous Corona case, hindi po pinayagan ng impeachment court yung Article 2.4 ng Article 2. At kung ang magiging batayan po natin ay yung naging mga desisyon ng ating Korte Suprema, sinabi mismo ng Supreme Court in several cases na pag ang usapin ay unexplained wealth, kailangan makita yung kabuuan ng kinita ng isang lingkod bayan at yung mga dineclare niya sa Salen. Just to quote just a very short portion, sabi ng Supreme Court from the same case I cited earlier, the Ombudsman's failure to account for all lawful sources of income, including proceeds from business ventures and government benefits, further weakens the allegation that Rafael's wealth was unexplained. The incomplete assessment disregarded his accumulated assets over decades of public service, making it impossible to determine whether his property acquisitions exceed his legitimate financial capacity, end quote. Hindi lang naman po dito sa harapan nitong hukom na ginagawa yung pagtingin sa kabuuan ng isang lingkod bayan. The Supreme Court has done it in this case where they looked at decades of the financial records of the person charged with unexplained wealth. And it has also happened in the cases of Rabusa and Ligot, which were decided recently by the Honorable Court. Thank you.
Your Honor, may I at least be given just 1 minute to respond to that, Your Honors? But of course, I will submit to the pleasure.
Of course, I yield. Of course, I yield.
The same opportunity, I'm assuming.
Yes, Your Honors. Again, hindi ko po tinutuligsa o ino-oppose yung mga na-mention na case ng aking distinguished opposing counsel. However, those cases do not involve impeachment. And why is that relevant? Because in impeachment, as we have said, merong allegation ng unexplained wealth pero wala naman pong nakasuporta na mga documents para makita natin ano ba yung basis na naging aligasyon. Pangalawa po, again in impeachment, according to the case of Duterte versus House of Representatives, meron po tayong tinitingnan kung ano ba talaga ang impeachable offense. At yun po ay again, offenses or acts or omissions committed while the public officer is occupying the impeachable office and in relation to such office. That enough, Your Honors, is very clear under the decision. That is all, Your Honors.
Thank you, counsel for respondents. Senator Judge Pia, may proceed.
Mr. President, Mr. Presiding Officer, I'll go to my next point, but it will kind of overlap with this point as well, so bear with me. My next point, Mr. Presiding Officer and parties, is still on due process. This is the requirement that every pleading must allege ultimate facts and must not contain conclusions of law. So again, I'll start with an example. If, for example, if there's a case filed, no, and sabi, si Juan robbed the house of Mario. So para maintindihan ng mga kababayan natin, Juan robbed the house of Mario. That is a conclusion of fact. Nangyari na daw yun. And if there's another allegation that says, therefore Juan is guilty of robbery, that is a conclusion of law. So again, I try my best not to be technical. It's in my, I would have wanted to be a teacher if not a lawyer, so I do like to be able to explain things well. So ang hinahanap dito is, bakit mo, gusto mong patunayan yung facts mo? Yun yung kailangan sa ultimate facts. Kailangan mo patunayan, bakit mo sinasabing Juan robbed the house of Mario? Di sasabihin mo, ang ultimate facts dyan example is si Juan ay nakita dun sa vicinity ng bahay ni Mario. Tapos ito si Mario, narinig na nagsisigaw na inanakawan kami o whatever. Tapos yun, meron siyang testimonya na ano yung nawala sa kanila. Tapos may nakakita na kamukha ni Juan yung nandun. Tapos namukhaan nila, na-describe nila na 5'10", medyo mapayat, ganon. So yun yung mga ultimate facts na later on sa evidence patutunayan. That's just very general, no? And then later on, para nga mapatunayan yung robbery, allege ngayon yung elements of the crime that constitute robbery. So, nung di pa ako abogado, di ko naman alam ang difference ng robbery and theft. Yung robbery kasi qualified yan eh. So pumasok siya sa bahay using violence. That's what makes it robbery. So kailangan na i-allege yun. Sorry to be a bit technical. Alam kong yan ang phrase of the day. Let's not be technical. Phrase of the week, phrase of the month. But we have to be able to explain these things in a way that people understand without forgetting that these are rights of the defense and rights of the person who is being tried here, and kailangan maliwanag yung ating mga accusations. So, my question now goes to both the prosecution and the defense. I know that the defense in their answer questions the failure of the complaint or the articles to allege ultimate facts, and therefore I think they filed the case before the Supreme Court. I'll give you your time to answer because I don't really recall that I heard it mentioned in the oral argument. So again, with the permission of the presiding officer, papasadahan ko lang naman na nabanggit ko yun na nandyan yan sa nandun sa memorandum, pero hindi ko naalalang, I'm just speaking naman for myself kung ano yung mga sinabi ko dun sa aming meeting, na hindi ko naalalang nabanggit. Baka naman nasabi, hindi ko lang naalalang na-emphasize kasi nga limited yung time. But I do recall that it's in the complaint, it's in the answer, and then it's also in the memorandum. So, pino-pursue nyo pa ba ito? Kasi me as a judge, importante to. Kasi paano ba didepensa ng maayos kung hindi nga nag-a-allege ng ultimate facts that go into the case? And then, for the prosecution naman, may I ask you kung saan because bawal ho na tanungin ko for you to state your case. I cannot do that, no? But what I'm asking is if you can point out sa inyong articles kung saan doon yung allegations of ultimate facts. Kasi public document naman yan eh. Para lang maaral ko na asan dyan yung allegations nyo of ultimate facts. And this is where, before I pass on the the floor to the parties to answer, I want to go into the principle of fishing expedition. Nagkataon na I came across the trial that we had for former Chief Justice Corona, and lumabas yung issue na yon. Nasabi ko, eksakto ito yung pinag-aaralan natin for today. Yung fishing expedition, and no less than the defense had to explain it in Filipino kasi sabi, baka hindi alam yung ibig sabihin ng fishing expedition, pangingisda ba daw yun? Parang hindi naman daw yun yung translation. No? Pero ito yung naghahagilap ka ng ebidensya kasi wala kang ebidensya. So I'll go back to a case and sama niyo to sa response nyo. Doon po sa kasong Afologencia versus Metrobank in 2014, humingi dito ang petitioner ng motion for issuance of subpoena ducis tecum ad testificandum at sinabing padala daw ng documents relative to their loan to Metrobank as well as those covering extrajudicial foreclosure. Sabi ng Supreme Court, this is tantamount to building their whole case from the evidence of their opponent. Bawal daw yun. Hindi daw pwede na yung kaso mo, nakabase lang dun sa, sasabihin mo dun sa kabila, labas mo nga lahat ng meron ka dyan. No, your case has to be built. Yung evidence mo has to be there. So I will also ask both parties, is that jurisprudence relevant to this case for the prosecution and then also for the defense? And then let us also include a discussion on why this is or is not a fishing expedition. Yun nga, napaka-importante po kasi ito dahil it is ingrained in a complaint na yung allegations mo ng ultimate facts, mapoprove mo ngayon yon with the evidence. Hindi pwede na wala kang ebidensya, hihingin mo lang ng hihingin by way of subpoena. Clear po yun sa batas. Kaya nga gusto kong ipaliwanag nyo sa akin, educate me why this applies, why this is not a fishing expedition, why the case I cited does not apply, because I assume that's the position of the prosecution. And then for the defense, ano naman po yung position nyo? Salamat.
The counsel for respondent will give his answer first with respect to the question of Senator Judge Pia on ultimate facts as well as on fishing expedition. Thereafter, counsel for the panel of prosecutors. You may proceed, sir, when you're ready.
Thank you, Your Honor. Pagdating po doon sa sinasabi namin na lack of ultimate facts, ito po yung nagsimula pa lang doon sa Committee on Justice when the impeachment complaints were filed. Because the allegation, and I'll stick just with this, I believe, Article 2. Pagdating po kasi doon, there was an allegation of unexplained wealth. Pero wala pong nakasulat kung saan nila nakuha, ano yung basehan ng unexplained wealth na yon? Ano yung act na ginawa ng Vice Presidente? Kailan yon ginawa? At so sa amin, para masabi nilang nagkaroon ng unexplained wealth. Ang basic, if I may remember, was really just the fact na yung SALN niya ay lumaki from 2007 to 2025, which sa aming palagay does not show any factual allegation whatsoever, except for the fact that it grew bigger over a span of 20 years. Pangalawa, wala rin pong naka-attach, which I mentioned in the oral arguments last week, na kahit anong ebidensya or kahit supporting document man lang, huwag na nating tawaging ebidensya. Supporting document that will support any allegation whatsoever of unexplained wealth. And that is why, nabanggit ko rin, na after the allegations were made, and this is even more significant, after the respondent had filed her answer, na tinawag pa nga nilang non-answer, doon lang po naghanap ng mga ebidensya na sakaling makasuporta doon sa aligasyon na iyon. That's very important for us because we had already filed our answer before AMLAC documents were suddenly produced with the issuance of subpoenas, before the BIR box that we are concerning ourselves with was presented before the Committee on Justice. Nasa panahon na yun, tapos na po kami sumagot. In fact, when they were saying that it was a non-answer, to be very candid with everyone, we wanted to say because it was a non-complaint. Kasi walang ultimate facts na naka-allege for us to even answer. Now, before this honorable court, I do recall that in our answer, we also took pains to discuss the lack of ultimate facts and also what we feel were violations of due process before the Committee on Justice, or at least with the proceedings that were conducted before the Committee on Justice. And that is also why we have a pending motion for exclusion na kinalakip namin dun sa answer, precisely because we were objecting to the fact that these pieces of evidence were produced after we had already filed our answer. Now, on the fishing expedition, I think on the fishing expedition, Your Honors, our main point is this. Even if we read the twin requests for subpoenas, ulit-ulit po, nakasulat po doon, because this may show context, because this may show, prove something. At para sa atin, this only shows, and at least, again, on the part of the defense, this is somewhat already an admission na hindi pa nga nila alam kung ano mismo doon sa mga hinihingi nila ang pwedeng sumuporta sa mga aligasyon na unexplained wealth. And that's why, if you read the entire request, it uses the word may several times, and it even says in one paragraph, I think it's 3.24, but I might be mistaken, that at least with the request for, with their memorandum, rather, in their memorandum, nakasulat po doon that this does not assume wrongdoing. But they want those documents nonetheless to see if something there will actually help support their allegations. That is why we are calling it a fishing expedition. Dahil in Tagalog, para po maintindihan, sa aming pananaw, sa dami ng hinihing dokumento, para po itong nagtatapon po tayo sa dagat ng isang napakalaking lambat at umaasa tayo na kahit papano may mabingwit kahit isang pirasong ebidensya. Maraming salamat po.
Counsel for the panel of prosecutors, the Honorable Jokno.
Thank you, Your Honors. The question propounded to this representation first is, what are the ultimate facts alleged in the articles of impeachment? Yung po ay nakasaad sa page 7 of the articles. And if I may be allowed to just read them briefly.
You may do so, Counsel.
Thank you, Your Honor. Respondent Vice President Sara Z. Duterte committed culpable violation of the Constitution and betrayed the public trust when she, A, amassed unexplained wealth manifestly disproportionate to her lawful income and earnings during her incumbency as a public official. B, failed to fully and truthfully disclose all her and her spouse's assets, liabilities, and net worth in her statement of assets, liabilities, and net worth, including in her salance for the years 2022, 2023, and 2024. And C, failed to divest and instead willfully continued all her business interests during her tenure as Vice President for the years 2022, 2023, 2024, and 2025. Please allow me to briefly explain why these are ultimate facts. Ultimate facts are basically the essential factual elements that make up a party's cause of action or defense. Halimbawa po, pag murder, treachery, evident premeditation, lahat ng mga kinakailangan ng batas para mapatunayan na murder po siya. In our case, we are alleging, first of all, unexplained wealth.
And based on the jurisprudence, the elements of unexplained wealth, the factual elements are amassing unexplained wealth, manifestly disproportionate to one's lawful income and earnings during one's incumbency as a public official. So, nasatisfy po namin yung requirement na pag-allege ng ultimate facts or essential factual elements sa tatlong bagay na po ito. The evidentiary facts follow in the succeeding pages of the articles. Doon po namin dinitalye kung ano yung mga iba't ibang paraan kung paano nakuha o naamas ni Vice President, yun ang sinasabi natin na unexplained wealth. On to the issue of fishing expedition. Yung pong fishing expedition po ay halimbawa may sabina na baka sakali meron tayong makita. Yun po ang ibig sabihin ng fishing expedition. When the party requesting information does not know what might be produced and just as an off chance tries to use that instrument in order to gain evidence that may be used against the other party. Dito po, malaki ang pagkaiba ng sitwasyon. Maalala po ninyo, during the hearings before the Committee on Justice, the Executive Director of the Anti-Money Laundering Council testified and produced documents showing that from 2007 up to the present, 6.7 billion pesos ang dumaan po sa account ni Vice President Sara Duterte. On that basis, and if we go deeper into that report, it says that during the period from 2007 to 2013, during the time that she served as mayor and vice mayor, umabot po sa halos o lampas 3 bilyong piso ang dumaan sa kanyang mga accounts. So may basehan po tayo para ipalabas ang bank records. We are not just guessing that there is something there because the AMLA itself has confirmed that there were covered and suspicious transaction reports submitted to them in those amounts that I mentioned. Malayo po ang fishing expedition sa ginagawa ng prosecution dito po. If we had no basis at all, if we did not know what was in the AMLA reports, ayun po, maaaring sabihin na fishing expedition. But in this particular case, we know because these are matters of record presented before the Committee on Justice. Second po, ang fishing expedition, maaring magamit yan sa ibang mga alegasyon tulad ng baka meron kang hindi na-declare sa iyong salin. But when it comes to issues of unexplained wealth, it's very clear. The decisions of the court are very clear. To know whether a government official has amassed unexplained wealth, we must look at the entire incumbency of that official. Starting from day one, we look at their salin, we look at all the income that he or she has earned, both lawful and not. And from there, we make a determination whether there was unexplained wealth or not. For these reasons, Your Honors, the fishing expedition argument, in our view, is totally untenable.
Senator Judge Pia, do you have further questions?
It's actually just a follow-up to what the prosecution, how the prosecution responded. I think Senator Alan Peter will go into it, but since this is my line of questioning, I'll follow up lang on this point, no? His Honor, I earlier mentioned the fruit of the poison tree doctrine. And ulitin ko, pagka yung pinanggalingan ng information nyo, bawal, hindi nyo na pwedeng gamitin yon. So, His Honor said, I'm referring to Congressman Prosecutor Chel Jokno, they know the contents of the AMLA report, something to that effect, because it was presented in the impeachment hearing in the House. That is correct, right? That is your statement?
Yes, Your Honor.
Yes, oo. And I asked my question, and again, I will give both parties the opportunity to respond. Ano yung basihan na i-reveal ng AMLC and their representatives sa inyo in the impeachment hearing in the House. Because ang nakasaad sa law, I don't even want to use my understanding of the law because it's what is read in the law. And I won't take up the time of this court na isa-isahin ko yun. Pero nakasulat doon na confidential ito. So ano yung basis na mailabas yon doon sa impeachment court? Because, and since the presiding officer has given me the permission to share in general the discussion in our caucus last week, isa doon sa napag-usapan namin precisely was yung information na lumabas doon, kung yan ay walang basihan na ilabas, walang legal basis na ilabas yung information, hindi yan pwedeng idugtong doon sa mga allegations na meron kayo. So that's my question. During our caucus, isa din sa lumabas na discussion, pero allowed ang AMLC and the specific officers to share that information. But the specific provision of the law, and please, both councils, please respond, please elaborate on how this supports or does not support your case. A specific provision dun sa batas, yung sharing of information na yon, sabi, oy, kayo AMLC Council, mag-develop kayo ng rules kung paano kayo makakapag-properly share sa agencies. I believe, and again, you feel free to elaborate on this or correct me. It's referring to the bank institutions, the AMLC hierarchy, and the agencies they deal with, not in court. Because, ulitin ko, nakasulat doon, confidential. So, I will leave this here, that if it is confidential, it does not allow that this be divulged in the manner it was divulged. Then how do you use that? Because that is precisely the doctrine of the fruit of the poison tree. Please take your time to tell us why that information is not the poison tree, and obviously in the side, for the side of the defense, they will tell us why they believe that it is the product of the fruit of the poison tree. Thank you, Mr. President.
Counsel for the panel of prosecutors will please respond.
Your Honor, Section 8A of the Anti-Money Laundering Law is really intended to prohibit or prevent leaks by officials of the Anti-Money Laundering Council. But it was never intended to prevent subpoenas coming from courts, including the impeachment court. Almost every week, the Sandigan Bayan issues subpoenas for AMLA records. And despite what would appear to be a very categorical prohibition contained in that section, every time subpoenas are issued by the Sandigan Bayan, they are honored by the AMLA and no one is questioning them. Ganun din po itong impeachment court. The subpoena issued by this impeachment court is for the purpose of determining accountability based on the power that is expressly given by the Constitution. Ang amin pong paniwala is that confidentiality cannot trump accountability. Thank you.
Counsel for respondent. May
Thank you.
reply.
Thank you, Your Honor. I cannot verify if indeed the Sandigan Bayan, as mentioned by opposing counsel, issues subpoenas against AMLA every week. So that I will not comment on because I cannot verify that. What is clear to us, Your Honors, as we have demonstrated last week, is that 8A is an absolute prohibition. And again, this was the latest amendment of the law back in 2021. And for us, Your Honors, that is why when this was presented, the House Committee on Justice, we had our objections to such matter. And in fact, Your Honors, it is the subject of our petition, the Supreme Court, and aside from that, a subject of our motion for exclusion before this Honorable Court. Ngayon po, sa atin, talagang yung tinutumbok natin is it is in fact within the fruit of the poisonous tree. In fact, I'm surprised, Your Honors, because, Your Honors, na nabanggit na rin po ng aking distinguished opposing counsel na nakita na nila, may records na sila. In fact, if I'm not mistaken, it was also attached to the articles of impeachment. So kung meron na pala, bakit pa nila pinapasapi na ngayon sa impeachment court? Is it because, I don't want to speculate, maybe I just won't go there. But ang sa akin lang po is, we have questioned this all throughout. No? Why? Because to us, unang-una, bawal siya. Pangalawa, hindi siya relevant. Bakit hindi siya relevant? Your Honors, transactions do not equate to wealth. Transactions do not equate to net worth. Especially if tinatali natin siya sa SALN. Because transactions happen over the course of the year, and in this case, years. But when you talk about SALN, we talk about net worth on a specific date in time, which is December 31 of every year. So sa atin po, ang aming pananaw dito ay hindi po relevant at hindi po, it will not directly show anything about wealth. Kasi, again, AMLAC transactions do not equate to net worth of a certain person. And that is why, Your Honors, we have opposed this. And we have opposed this since the time it was being presented at the House level. Thank you, Your Honors.
Just for the record and for the information of the senator judges, I'm not sure about the Sandigan Bayan issuing a subpoena every week as well against AMLAC. But I'm well aware, the court is well aware of cases decided by the Supreme Court precisely on subpoenas issued by the Sandigan Bayan vis-a-vis the AMLC. Senator Judge Pia, can you wind up? You're done? At this juncture, Chair will now recognize Senator Judge Alan Cayetano for his interjection and questions. You may proceed, sir, when you're ready.
Before I ask question, Mr. Presiding Officer, may I thank you, the Senate President Win Gatchalian, former Senate President Tito Soto, and the whole court, because in our caucus, you did three things. One, you allowed us to have the weekend to review all of the laws so that we can ask more intelligent questions. Two, you allowed to hear the discussions, mostly by Senator Pia, Senator Pangilinan, Senator Lacson, and former Senator Soto. And then number three, we discussed how a complex, or what word did you use a while ago, Mr. Presiding Officer, that it's two motions, but there
May be issues underneath.
issues and sub-issues. So that after we ask questions and after you make a ruling, we'll, instead of asking for a division of the House just in case we do not agree, I'll make a manifestation, and then if others agree on how we can manifest or submit in writing in what parts of the ruling we agree or disagree for the record. May I proceed, Mr.
Duly noted, Your Honor. You may proceed, sir.
Good afternoon, Attorney Jokno and Attorney Poa.
Afternoon, sir.
Yeah. So I really want to be enlightened. I have no illusion na magkakasundo yung dalawang side today because you have the eloquent Attorney Jokno on one side and the eloquent no joke on the other side. So sa pangalan pa lang baliktad na. But I think the discussions are very important, and I do appreciate your opening, Congressman Jokno. I appreciate your oral arguments because I've been pondering these questions. What if, hindi ko na sabihin this administration, let's say in future administrations, this exact thing happens, 5 years, 3 years, 10 years, iba ang SALN, iba yung income ng COA chairman or ng ombudsman files cases, mukhang maraming congressman makakasuhan ngayon. So very, very much relevant yung ating pinag-uusapan ngayon. So just in the spirit of liberality, same kay Senator Pia, after one answers, if one wants to make a quick rebuttal, I'll ask you the question, but let's try to be concise. So Council, may I ask, let's start with the case of Duterte versus House of Representatives. Thank you for reminding us about certain precedents and how I voted last time. But you would agree, di ba, that when you have legal proceedings, even in legislation, you follow what the latest law is. So, for example, if you're allowed to issue a general warrant before Stonehill versus Jokno, but after Stonehill versus Jokno, so if before Stonehill versus Jokno, walang doctrine of the fruit of the poisonous tree, then some policemen will still submit evidence that was illegally acquired. But after that, we have to follow. So you did make your point about obiter dictum. I'll go to that. But I just want to start out by saying the fact is there is a Duterte versus House of Representatives. So with your permission, let's start discussing that. So this case of Duterte versus House of Representatives came out after the impeachment of CJ Corona, correct?
Yes, Your Honor.
And the two elements was discussed in this case. The act charge must be impeachable under Article 11, paragraph 2 of the Constitution, and 2, the act committed must be committed during the term of the impeachable officer. You commented on that. Can you elaborate or give your stand regarding, I think you agree with letter A, right? That the charge must be an impeachable offense. I mean, we all agree on that, right?
Well, I would distinguish, Your Honor, please, between what we would call ratio decidendi, or the rule in that particular case, and obiter dicta, which are side comments or incidental remarks made in the opinion of the court. If we are speaking of the ratio decidendi of the Duterte versus House of Representatives case, I would have to disagree that it relates to the statements that you mentioned. My understanding of that case is it really relates to the first mode of impeachment and the procedures that must be followed, the one-year ban provided in the Constitution, how that will be applied when impeachment complaints are filed. Yung pong nabanggit nila that the basis of any charge must relate to the incumbency of the official. In my view, that is obiter dicta, not necessary.
I appreciate your answer. We'll go to that. But regardless of the Duterte versus House of Representatives ruling, we do agree with letter A. The act charge must be an impeachable offense under Article 11, 2 of the Constitution.
I would agree, but if
Yes.
I may be allowed to just qualify.
No, this is just a
that.
general. It's not a trap question. So,
No,
diba, so the officer has to be impeachable, and the act charge should be an impeachable offense. And since you have betrayal of public trust, that's quite broad. No? So this is not a trap question. This is just laying the basis. But go ahead if you want to comment on that.
Yes, the acts charged must constitute an impeachable offense, and that power to decide what is an impeachable offense is lodged exclusively with this honorable court.
Okay. So you disagree that part of the ratio decidendi is the act must be committed during the term of the impeachable officer. Thank you for bringing it up now, because I think all throughout the trial, especially in the articles where we will bring up acts before 2022, this discussion will be relevant. No? So by discussing this, it will pass upon the whether or not including proof like bank records, financial documents, before her term can be inquired into. The prosecution says it cannot, right? Because you believe it's an obiter dictum. I'm just restating, but you can say it in your words. You believe that the statement that the act must be committed during the term of the impeachable officer is not the law of the land. It's an obiter dictum.
In the first place, if Your Honor, please, that was not the exact statement of the court.
Okay.
The court said the basis of the charge must relate to the incumbency of the impeachable official,
Yes.
which does not rule out the presentation of evidence of acts or omissions that occurred before the person became an
So
impeachable
let's
officer.
take the judicial notice of, as you said more eloquently and correctly, that the acts during her term. So can you define, you defined this in your opening statement, but for the sake of this discussion, an obiter dictum is what?
It's a side comment, Your Honor, that is not necessary for the resolution of that case.
Yeah, and I agree with that, and it's a remark made or opinion expressed by a judge in a decision upon a cause, or it's a by the way,
that is incidentally or collaterally and not directly upon the question before him, or upon a point not necessarily involved in the determination of the cause, or introduced by way of illustration, analogy, or argument, such are not binding precedents. No? Just for the public and for all of us, di ba?
Yes.
So ang sinasabi, yes, there can be a Supreme Court decision, but that part, interdictum, meaning hindi yan yung doktrina that will bind us in making decisions, whether it's issuing the subpoena or not, or admissibility. But are you aware of the Villanueva versus Court of Appeals, GR 142947, March 19, 2002? I won't take it against both of you if you do not. There are thousands of cases. It talks about what is obiter dictum. Have you passed about on this, both counsels?
For me,
Yeah, so the prosecution characterization of the requirement that the basis of the charge must be for impeachable acts or omissions committed in relation to their office during the current term of the impeachable officer as an obiter dictum. But in the Court of Appeals, Villanueva versus Court of Appeals, in that case, the Supreme Court held an adjudication on any point within the issues presented by the case cannot be considered an obiter dictum, even where the point is only incidentally involved. So we agree if it's incidental, pwedeng obiter, but if it's on point within the issues, sabi ng Villanueva case, it is not. So long as it is presented and decided in the regular course of the consideration of the case and led up to the final conclusion, or is a statement as to the matter of which the decision is predicated. The court added that a point expressly decided does not lose its value as a precedent because the disposition of the case is or might have been made on some other ground, and that where a court decides several points, none of such points can be regarded as having the status of a dictum. And one point should not be denied authority merely because another point was and more dwelt on and the mode of initiation, that regardless of the mode of how the articles of impeachment got here, isn't due process still a requirement?
If I may be recognized,
Yes.
Your Honor.
Counsel for the panel of prosecutors may respond.
Precisely, Your Honor. If a matter is within the issues resolved by the court, then it may not be considered as obiter dicta. But if we look at the decision in the case of Duterte versus House of Representatives, ang mismong nangyari po doon ay may naunang dalawang complaints that were endorsed at may sumunod na complaint filed by at least 1/3 of the members of the House. At yun yung tinutukan po ng ating Supreme Court. It was in that context that the Supreme Court made pronouncements about the one-year bar and even about due process. At no time in that case was it ever a fact in issue about the mode of impeachment that is involved in our case today. Ang pinag-uusapan po natin dito ay individual complaints that were then referred by the House to the Committee on Justice, heard by the committee, and then brought back to the plenary and eventually umabot po dito through articles of impeachment. So kahit may sinabi ang Supreme Court about impeachable offenses in relation to the charges, kami po ay naniniwala na hindi po yan pumapasok o sumasakop sa issues that were decided in that case.
I'll not argue with you because that's not my job here. I'll follow the Pia Cayetano style and move to the defense. But just a follow-up question on that. So I respect your belief on that. But my point is, the legal principle of due process applied to that mode, is it not logical that it's the same legal principle on due process even if you use another mode?
First of all, if Your Honors, please, when we speak of due process, of course, there are two types, substantive and procedural due process. And when we speak of substantive, we're talking about protections to life, liberty, and property. Wala naman pong ganun na issue po dito sa atin because office is not a property. We're not talking about the life or liberty of the respondent. Ang pinag-uusapan po natin dito kung due process ang issue, ay simply fundamental fairness. And I do believe that this proceeding does require fundamental fairness, but at the same time, it does not require that this court be hamstrung in terms of how to decide whether an offense is impeachable or not. That power is exclusively given to this court at dapat kayo lang po ang magdesisyon at magpasya kung ano nga ba yan. So when we speak of what is an impeachable offense, may kaugnayan po yan doon sa nabanggit ninyong the basis of the charge must relate to the incumbency. Because in our view, that is really something that each member of this honorable court will have to decide when the time comes.
Yeah, later on, I'll ask you that question, whether or not, what, if ever, can the Supreme Court decide, or what of their pronouncements will be applicable to this court and that. But my point is, if we're saying that pag ang mode of initiation is by 1/3 na pumirma diretso, at ang nakalagay doon committed in relation to their office during the current term, wouldn't it be illogical if you use another mode and pwedeng hindi committed in relation to their office and during their current term? I don't think the Supreme Court would be illogical in saying this is the principle for due process in this mode but not in this other mode.
Even if we assume, Your Honor, that that is not obiter, the statement that the basis of the charge must relate to the incumbency of the impeachable officer, we submit that that still applies and we have satisfied that test. As I mentioned in my opening statement, integrity cannot be divided. Hindi po pwedeng biyak-biyakin ang integridad.
So on that point, so if President, an ombudsman, a COA chair, who's let's say 60 years old, but he started in government at 20 years old, he can be impeached by something he's done when he was 20 to 30, not only on what he's done when he was already an impeachable officer.
If we are speaking about unexplained wealth, Your Honor, I have repeatedly cited the cases of the Supreme Court that provide that we must look from the reckoning of the first day of service of that public official. Look at all the income that person has amassed and determine whether it is manifestly disproportionate to the lawful income that he has reported.
Yes, I agree in terms of holding that person liable and accountable. But what I'm saying is that, let's say he was a councilor, then he was a customs director, then he was BAR, then he's now COA. Isn't the remedy for all his other positions that weren't impeachable is through the regular courts and regular case build-up, etc. But once you're an impeachable officer, you're being held accountable during the term that you are, in fact, an impeachable officer, because usually when you're an impeachable officer, it's too hard to prosecute you the normal way. Isn't that the logic there, or you disagree, counsel?
I would have to respectfully disagree. Ang pinag-uusapan po natin kasi dito ay betrayal of public trust. And I think it's very clear that when we speak of betrayal of public trust, essentially we are looking at whether the public official is fit or unfit to continue in service. Kung siya po ay nakapag-amas ng unexplained wealth, nung siya ay vice mayor o mayor na umaabot sa bilyon-bilyones, I think that would have a very big impact on the court's decision, whether that person should continue in office or whether they are fit to have that office.
Okay. As I said,
With the permission of Senator Judge Alan Cayetano, with your indulgence, sir, a request was conveyed to the presiding officer to declare a very brief break. This is not a break for all of us, but a very brief break of 5 minutes, so that council may answer to the call of nature. That was the message conveyed to the presiding officer, including Senator Judge Cayetano. So Chair declares a 5-minute break. We shall resume at 4:05.
Officer. So that is why, Your Honors, is the view of the defense na hindi po obiter lang itong pronouncement ng Supreme Court na to as to what constitutes as an impeachable offense.
Yes, I'm not texting. I got on my phone the Duterte versus House of Representatives because, of course, my follow-up questions was to get into the mind of the prosecution when to apply the Duterte case and when not to. So, but I'll still ask you the same question. So, what's more logical, that the due process requirement that that the acts committed should have been on the term is also applied to the other modes or just to the one-third mode?
All modes of impeachment, Your Honor. That is our position. Kasi po, we would veer into absurdity, no? Na kung dun sa one-third mode tayo, ang impeachable offenses limited lang sa term, pero pagdating doon naman sa other mode, which dinaanan, admittedly, at yun ang dinaanan itong current proceedings natin, mag-iiba ang definition ng impeachable offense. I do not see any logic on why there's a difference because an impeachable offense is an impeachable offense. So para po sa atin, that should apply. And in fact, the Supreme Court did not make a distinction as to the guidelines that it laid down in that decision, Your Honors.
Yeah, so in the first page, sabi dito, second, considering the nature of the offices and the institution that are subject to impeachment, in effect, its effect on the independence of constitutional departments and organs, and its nature as a constitutional process, all legal issues involving impeachment proceedings are subject to judicial review. While the court does not determine when, who, and whether an impeachable officer may be removed and disqualified from political office, it has the duty to construe and process mandated by the Constitution. So is this for you part of the res decidendi, or is this a obiter dictum?
Ratio, Your Honors. In fact, that's why the Supreme Court, when it started decision, said that the end does not justify the means, no? Because it was precisely discussing the means. Ano ba yung dapat nating sinusunod na proseso?
Yeah. So since we're talking about subpoenas, we'll go to the end and the means, the justified means.
With the permission of Senator Judge Allen, I would just like to get the assent of the counsel from the panel of prosecutors. The documents ought to be distributed by the counsel for respondent is a July 25, 2025 discussion on the Duterte v. HOR on the one-year bar rule. Again, it's dated last year. With the permission of the prosecution, we shall distribute it without prejudice to the counsel for the panel of prosecutors to also furnish whenever it shall so desire, because this issue, as pointed out by Senator Judge Cayetano, will linger until the end of the proceedings, without prejudice to the counsel from the panel of prosecutors to so furnish also Senator judges with their rejoinder to this document being furnished to the senator judges. Is that okay?
Your Honor, I believe that, first of all, may we request for a copy of that document. I believe that document refers to the office of the spokesperson.
That's correct.
Of the Supreme Court, in which case, Your Honor, we would have to interpose an objection because any interpretation by the office of the spokesperson is not binding on the Supreme Court. What we must look at are the actual texts of the decision.
Well, counsel, you can say that in your rejoinder. Point that out in your rejoinder and point that out in your submission.
We will do that, Your Honor.
So ordered. Clerk of Court is directed to kindly distribute the copies to the senator judges without prejudice to the panel of prosecutors submitting a rejoinder to this document.
Yeah.
Senator Judge Alan Cayetano, you may proceed, sir.
Yes,
Apologies for the interruption.
Presiding officer, to be fair to I wouldn't have objected if you objected to the distribution, but realistically, we won't have time to read it because magro-ruling na after.
Yes.
So it'll be more of reference materials. But feel free also to, if you feel that you should submit in writing a rejoinder to be fair to everyone. So if the voting was tomorrow, and it would be unfair to distribute it. So can I ask the same question, Congressman? So I read, it's the first few paragraphs, no? Sabi kasi dito, you heard me naman now, you want me to read it again, or?
If I may be allowed to respond already to the
Yes, go ahead.
question. First of all, Your Honor, I think we must point out one of the plainest reasons why that statement in the Duterte ruling is obiter dictum. And that simply is because there was no trial yet to speak of when the Supreme Court rendered that decision. Paano po magiging issue yung nangyayari ngayon sa trial, samantalang nung dinesisyonan po yan ay wala pa pong trial. Therefore, any statements by the court about how the trial should be conducted are outside the issues of that case. And while they may be guidelines, they are not binding as judicial precedent to us and to the future generations.
Actually, I was referring to a different matter already, but just to that point, it's not how, it's what. Because it's paragraph 6. So the basis of the charge must be for impeachable acts or omissions committed in relation to their office and during the current term of the impeachable officer. For the President and Vice President, these acts must be sufficiently grave, amounting to the crimes described in Article 11, Section 3.1 of betrayal of public trust given by the majority of the electorate. For the other impeachable officers, the acts must be sufficiently grave that they undermine and outweigh the respect for their constitutional independence and autonomy. So this doesn't really tell us how to conduct the trial. This basically tells us is that if we don't follow that, we're endangered of having a trial that's void ab initio.
I would have to respectfully disagree, Your Honor. I believe-
Anyway, we've gone through that argument, and I won't argue with both of you. Going back to this is what I read, no? Second, considering the nature of the offices and the institutions that are subject to impeachment, its effects on independence of constitutional department and organs, and its nature as a constitutional process, all legal issues involving impeachment proceedings are subject to judicial review. I'll stop there. Kasi nabanggit mo kanina, may I speak English Filipino? Nabanggit nyo po kanina na that's for us to decide, and my interpretation, and I've felt like that many times, diba, na zealous dapat ang impeachment court sa powers niya kasi not only because it's sui generis, wala tong apologize to Senator Judge Risa, my phone fell there. So, wala nga tong, you cannot appeal the decision of my belief, no? You cannot appeal the decision of to acquit or to convict to the Supreme Court, diba? But the parameters, so let me use the words of the Supreme Court, no? Ang sabi niya, all legal issues involving impeachment proceeding are subject to judicial review. So you disagree with this or you agree? In context ng sinabi mo kanina na it's within our power to make these decisions.
I believe what is the controlling decisions there, Your Honor, are the cases of Gutierrez and Francisco. Because those, the issue of what is an impeachable squarely brought before the court, and the court said very clearly that is purely a political question that's not within the judicial power for us to decide. And I believe that that should be the controlling jurisprudence.
So let me be more specific. So for example, we issue some subpoenas and we do not issue some. Can one or both of you, meaning the
some side, perhaps the defense may claim that there's a grave abuse of discretion, I believe, as they have done in their other petitions filed, and therefore make an attempt to stop the proceedings before this court. But as I have said last week, Your Honor, in our opinion, it is this court has the sole and exclusive power to decide what an impeachable offense is, and
No, Your Honor.
No,
I have a different.
So, okay, you can go back to that question. Then my follow-up question was, so let's say certain orders of the court, can the prosecution or defense go up to the Supreme Court and question its constitutionality?
Yes, Your Honor. It is our position that either of the parties can do that. Why? Because sa atin nga, ang sabi natin kanina, that the Constitution cannot be read in isolation. So while the Constitution gives the sole power to the Senate to try an impeachment case, to try and hear an impeachment case, we must read this in conjunction with, again, Article 3, Bill of Rights, and Article 8, specifically Section 1, which is the power of judicial review. So pag sa tingin po ng isang panig, merong grave abuse of discretion na naganap, we are of the position that in fact, this is a justiciable issue and can be brought before the Supreme Court, Your Honor.
So at least in that small point, I think we all agree that if we think there's grave abuse of discretion, there's a possibility that the Supreme Court will take it up. I'm not referring to the subpoena, I'm talking in general. So I'll skip a few pages of my questions precisely because I wanted to elicit your opinions or your stand regarding the fact that the impeachment court is supreme, but it's not true that we can do anything or we can just make decisions that are not based on statutes and on legal orders. In fact, when the Supreme Court issued a TRO regarding the foreign accounts or the dollar account in the Corona case, the impeachment court voted to respect the TRO, no? But of course, we did vote. So there could have been a constitutional crisis if we voted not to. And then, of course, we know because of history, nag-waiver na lang si Chief Justice Corona, no? So can I go now to the ultimate facts, no? I don't know if Senator Joel, but Senator Pia asked a little bit about this. Just a quick review, or maybe, so we're also governed by the rules of court when it comes to ultimate facts. This is what Section 1 says. In general, every pleading shall contain in a methodological and logical form a plain, concise, and direct statement of the ultimate facts, including the evidence on which the party relies on his or her claim of defense, as the case may be. If a cause of action or defense relied on is based on law, the pertinent provisions thereof and their applicability to him or her will be clearly and
The distinction, Your Honor, between what we call ultimate facts and evidentiary facts, which are the pieces of evidence that could be used to come to the conclusion or to decide whether those ultimate facts are present in the case or not.
yeah, I think all of us lawyers agree with that. There's a difference between ultimate facts and evidentiary facts. But the rules of court says, including evidence. Kasi kung walang including evidence, ang kailangan mo lang i-file ultimate facts. Pero pag sinabing kasama ang evidence, question. So pwede bang sa articles of impeachment, ultimate facts lang, walang naka-attach na evidence?
Ang requirement po sa pleading ay doon na dapat nakasaad ang ultimate facts. But if you look at the articles of impeachment that are before this court, it also contains evidentiary factual allegations to support the ultimate facts that are contained therein.
Thank you for that answer. Actually, that was my next question. Did it contain? And you answered it. So with respect to the Saballa and Cabrera impeachment complaints, is it correct that there was no authentic records that were attached when they were filed? Factual lang tong tanong ko.
If Your Honor, please, first of all, I would have to raise an issue with respect to whether this honorable court is acting as an appellate or review court of what happened during the House proceedings. The power of to initiate an impeachment complaint is exclusively lodged with the House, while the power to try and decide that impeachment case is exclusively lodged with this honorable court. And I don't believe that it is part of the function to go back to what may have happened during the proceedings before the House, since the articles have already been transmitted to this honorable.
Well, Counsel, even your students, colleagues recognize that you are a brilliant man. You're very well learned sa law. But minsan mabilis kasi actually that's not where I was going. Binaliktad ko lang. So two of my colleagues started with or in your discussions, ano yung fishing expedition going down to ultimate facts and evidentiary. Ako, I wanted to distinguish when is it a fishing expedition and when it's not. So I just wanted to know as a fact. Or can we take judicial notice that there was no authentic records in the Saballa and Cabrera?
What's the point again, Senator Judge? There were no
it was-
authentic.
It was just preliminary because I wanted to compare it with other impeachment complaints. And I wanted to ask the question, when is it a fishing expedition or hindi? So these are legitimate questions. So factually, yung Saballa and Cabrera ba, may authentic records attached. Ang information ko wala. But I don't want to...
I believe, Senator Judge Alan, that the Zabalya and Cabrera complaints were attached as an annex,
Yes.
if I'm not mistaken, to the respondent's answer. Would that be
Yes.
correct, Attorney Poe?
And to be fair,
Yes,
it was...
As well as the annexes.
Yes, Your Honor.
In fact, the presiding officer noticed that it lacked a page in one of the annexes to the, I think, Zabalya complaint,
So
which
anyway,
I think pointed out. So that's a fact.
Yeah,
So it's in the
lang-
records, Senator
yeah,
Judge
factual
Alan.
lang po. So, in the absence of authentic supporting record,
attachments to both complaints. And I'm not aware of any asked or investigated by the committee to only what is contained and attached to the
yes,
impeachment
I'm not
complaint.
questioning if there's an attachment. I'm questioning whether there was, I'm asking question. I'm not even questioning it. I'm asking questions on if there were authentic records. So I'll fail to establish any factual nexus between the president and an impeachable offense. What are presented were policy and disagreements and generalized accusations, not ultimate facts. Yun ang finding ng Committee on Justice. Correct?
Yes, Your Honor, to the best of my recollection.
So that's my question. After answering that question, does the prosecution agree that the requirement of alleging ultimate facts applies equally to all impeachment complaints, regardless of it's the president or the vice president, regardless if it's the ombudsman or the COA chairman?
Yes, Your Honor. And as I recall, when the members of the committee examined the complaint filed against the president, the conclusion of the committee was in fact that there were only conclusions of law contained in that complaint, not allegations of ultimate facts.
Yes, yet in that complaint, there were documents attached, authentic records, and the House did not ask na masupina yung AMLA, BIR, and bank records of the president.
The requirement, if Your Honor, please, of ultimate facts is really based on what is alleged in the petition or complaint
But
itself.
what was the exact words of counsel? Ang katotohanan ay hindi
Confidential.
confidential. So why in the case of President Marcos is the katotohanan confidential, but in the case of Vice President Sara, it's not confidential?
Wala naman po akong maalalang ruling ng committee in the case of the president na meron silang sinabing confidential.
No,
What I recall is that the conclusion was that the complaint did not allege
Yes.
ultimate facts.
So there was a conclusion even before asking for all of this. But in this case, there was a conclusion that there's no nexus between the president and an impeachable offense. In this case, walang authentic documents pero humihingi ng supina kasi yung katotohanan hindi confidential. So, which goes to my, first, let me honor who I should honor because it seems that the Lisa Masa complaint, which was endorsed by ACT party list, was here kanina, and I think Antonio Tino, I think Sara Elago was here the last week, and I think Representative Ko was here. So in their case kasi, I can say walang selective justice because they wanted the same standards of president and vice president. So that's my next question. We want fairness for everyone and for the Filipino people, but would it be unfair to require 20 years of documents from AMLA, BIR, and bank accounts from Vice President Sara without requiring the same from President Bongbong, considering that all of these scandals is happening during his administration?
If the allegations of the complaint against the president did in fact contain ultimate facts, I would see no reason why the Committee on Justice should not have proceeded with it.
So I'll take that answer. May I ask the defense on this?
The defense follows strictly the rules, Your Honors. While I agree with the distinguished opposing counsel na iba yung ultimate facts and evidentiary facts, no? I don't want to blur that line. Tama naman po yung sinabi ng ating opposing. But yun nga po yung punto namin, no? In the Zavalya and Cabrera complaints, wala pong ultimate facts at wala din pong evidence or evidentiary na nakakalakip doon po sa mga complaints, and which is the very issue that we brought up to the Supreme.
That unless it is relevant and definite, I read in your pleadings, diba, and in your position paper na yun yung. So kasi I'll ask na rin my next question. Why is it definite in your view?
Opo. So on the first question, yes, Your Honor. Even if I were to be representing the President now, I would have the same view, no? Na hindi po pwedeng ganun ka 20 years ang span ng mga documents na hiningi, precisely because the jurisprudence provides that for as to why it is not particularly described. Your Honor, unang-una, let's start with the bank accounts. No? Yung bank accounts na naka-enumerate sa kanilang request, it is our position na yun po yung natawag kanina na fruit of the poisonous tree. Because as you can see, lahat po ng pinanggalingan na accounts na yan ay yung AMLAC. But which we are contesting, no? Sa amin po, unlawful po yung naging disclosure sa Committee on Justice. But more importantly, pangalawa, aside from just the mere bank accounts, the documents they're asking, Your Honors, while they are specified, kung titingnan mo talaga ng mabuti kung anong hinihingi nila, they're asking for all they have stated in the articles of impeachment.
I'll skip many questions here and go to that question. But to be fair, Congressman Dioknos, he said that's an exclusive authority, right, power of the House. So if I want to question the difference, I'll do that in either the Senate or as a private citizen. So I won't go into that. But I ask that now in context of whether or not the certain parameters in the subpoena you're asking for is valid or not. So let me just go to this series of questions. This is really a discussion into what is substantial facts, what's ultimate facts, what's essential facts, what are, and as you said, Attorney Powa, we don't want to bore everyone with that, but it's important in terms of due process. So basically, diba, the ultimate facts are that establish the charge, in this case, unexplained wealth. So let me put it this way in my question to Attorney and Congressman Prosecutor Joke. So like if I say that may kilala akong politiko, commissioner ng ganito or congressman, senator, whatever. Ang SALN niya was 1 peso or what's a reasonable amount. SALN niya was 1 million, 20 years later it's 20 million versus the commissioner of BIR in 5 years it gained 50 million compared to this congressman nito. Then I said, eto lang income niya, unexplained wealth yan. In your view, is that sufficient na for the impeachment court and to issue the subpoenas? Or do you have to specify na, for example, you say that that commissioner, sa SALN niya, he only had 2 cars. But he actually has more than 4. Therefore, penging subpoena para sa LTO. O that commissioner, ang sabi niya, isa lang ang bahay. Yung ultimate facts. Pero yung pag sinabi mo lang, eto SALN, eto tumaas, which was my point actually in my last few vlogs, that just because tumaas yung SALN, that doesn't mean that there's ill-gotten wealth. But my question there was, does that give us now the authority to get the bank accounts, the AMLA and the BIR? Because whatever we do in the impeachment court is for impeachable officers. But nanonood din yung Sandigan Bayan, nanonood din RTC, MTC, nanonood din yung Supreme Court. So whatever rule we have here, that will influence then how we deal with barangay captains all the way to anyone who's not impeachable, no?
For unexplained wealth, Your Honor, I believe the ultimate facts must include the following. First, that the person involved amassed wealth. Second, that wealth is manifestly disproportionate to that person's lawful income. So kailangan po natin makita kung ano yung kanyang kayamanan at kailangan natin ikumpara doon sa lehitimo niyang kinita. And that can be only determined by looking at the records that we are requesting from this honorable court.
No, but if you're just looking at the SALN at yung kinita niya, so I'll give you a example. I won't name the person para walang mag-react. But he was senator, I think in 1987, an outstanding human being. And he was telling us